Now joined by Dr Abhishek Manu Singhvi, Senior Advocate at the Supreme Court and Rajya Sabha MP of the Congress. Thanks, Dr Singhvi. Now, Justice Abdul Nazeer has been appointed Governor of Andhra. He retired very recently. He was part of the Babri Masjid trial dispute. Obviously a very sensitive case. Do you think it was appropriate for him to have accepted this post?
Look, Vishnu, there are several facets. First of all, this is nothing to do with the person and individual. It is to do with principle. As a matter of fact, he's an excellent person. He's a gentleman. I have known him. He's a very fine judge. Nothing to do with him. The matter of principle is that we are now talking of threat to the independence of judiciary, which, by the way, people have forgotten, has been held to be part of the basic structure of the Constitution several times. Really, it means that you and I, even if we do a constitutional amendment, cannot affect it, cannot change it. Now, what is happening is in the last few years in particular, in the recent past, thick and fast, shortly after retirement, you are having appointments to political posts. Yes. Semi-political and political posts. And yes. Second, you are having them in the context of people involved who have been involved in highly sensational political matters. I think this is the gravest threat to independent judiciary and should be discouraged. It is nothing to say that, look, Vishnu Shom did it, so Singhvi should do it also. This is nothing but political whataboutery. It has happened in the past, but let me tell you, in the somewhat distant past, not so repetitive and not so blatantly political. And let me also say that today it is much more shown about perception and appearances. I'm not here to prove that Mr. Vishnu Shom was given this because he did this, that or the other. It is about the perception of Shom and, more important, about the system of which Shom is a part.
No, but so the other point that's being raised is that Justice Nazeer is the third judge of five, to be named for a post-retirement job. Again, that raises questions. Again, it's difficult because the intention of asking that question isn't to cast any aspersions on the judge in question, and it is his independent choice. But that is a question being asked, and it's a question being asked by you certainly. So how would you look at that? Would you make that linkage?
I don't think we talk of only that case, but I think we certainly talk of the fact, and there's no point talking about others. Now we're talking about a specific case. It really is the same answer. You need to avoid this. See, and another kind of a fiction and a problem created is to suggest you, oh, what's the problem? You're appointing people to judicial posts all the time. There is a huge difference. And let's keep that difference alive. Arbitration is one. Appointment to tribal posts is another category. These are adjudicatory, judicial, semi-judicial functions. But ultimately, if you are living in an ivory tower, I can't say. But a governorship is not a adjudicatory function. It is not a judicial or a quasi-judicial function. It's the most heavily thicket of political power. If you don't smell the coffee and you don't see what's happening around you in governorships, you know what, you're living in a different world.
So, Dr. Singhvi, Arun Jaitley said, in fact, in 2012 that pre-retirement judgments are influenced by post-retirement jobs. For whatever the reason is, the BJP appears to have ignored this, or they've forgotten about it. But is this something that you believe is right, and something which all political parties should believe in? I ask this because even when the Congress has been in power in the past, there have been governors or there have been judges who've ended up as governors. So isn't there a bit of a double standard, for the Congress?
No, let me be very clear. We quoted this. I did a press conference yesterday where I mentioned this. My colleagues have mentioned it. The point is, it's the principle there. Pre-retirement action is certainly determined by post-retirement expectation. Now, it's the principle which needs to be sanitized. And let me also say one thing. Beyond this, in the future, you and I can keep on giving sermons that our expectation is that we'll have a clean system. We will not have this happening. And we express fond hopes. And the judiciary can give sermons in their judgments. Nothing is going to happen unless you do either a constitutional amendment or a statutory amendment. I think the time has now come. At least you can categorize in that amendment that these categories yes, these categories no. Absolute stoppage. So there's no issue. And let me end by reminding you of a rather, tender moment. H.R. Khanna was God's good man, and he was treated unjustly for a variety of reasons. I have no doubt, hesitation saying that. The man much later became the law minister. People forget that. He became law minister and resigned within 48 to 72 hours because he was uncomfortable in his conscience with people said that, look, your stature is more than this. You don't need to demean it by being used. And there'll be always come to use and misuse. Today I'll be there, tomorrow you'll be there, somebody will be there always. It is ultimately either a statutory constitutional amendment or you need to simply, shrug it off and say, look, I'm not suited for these things.
So, Dr. Singhvi, one final question. Kiran Rijiju has said, and let me quote, the whole system is in full swing in the appointment of, the whole ecosystem is in full swing in the appointment of the governor. They should understand that they cannot treat India as their personal freedom. India will be guided by constitutional freedoms. How would you respond to that?
Vishnu, if you ignore the last 4 words, you tell me for the whole sentence, the whole paragraph, is there anything he has done about the issue at hand? Has he said anything at all about the issue at hand? I'll come to the last 4 words. Nothing. It's the same gentleman who wanted to throw basic structure out of the window. It's the same gentleman who wanted, despite 3 judgments of 7 judges, to have his nominee or the government's nominee sit as a collegium. What can I say? I think it betrays a remarkable lack of knowledge, sensitivity and ignorance about the way the judicial system functions. And I think it is being that same lack of the knowledge about the intricate spirit of the way the judicial system functions is betrayed in this statement. Yeah. Now, yes, I agree with the last 4 words that you can go on taking this, tom-tomming this silly point that there is no constitutional bar to appointing Vishnu Shukla as a governor.
Yeah.
Well, you decide for yourself, is that a fair answer?
Okay.
But in any case, I am suggesting that now you should take care of it once and for all. Otherwise, you keep collectively.
All right. Okay, Dr. Singhvi, thanks very much.